Is your business protected against the threat of malicious litigation and frivolous lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. Now, whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
All right, welcome, folks. Good morning. I'm Rick Moscoso, your co-host here on the Bottled Business Sense show. I'm here today with my other co-host, Bill Bernard. How you doing today, Bill?
I'm doing great, Rick. Good to be here with you. Good morning, everybody. Glad that you're all here.
Well, today we have an exciting show planned. Bill is going to speak today about estate planning 101. But before we get into that, the Bottled Business Sense show is really a casual talk show that
Yes.
Bill and I wanted to offer to our viewers. We talk about different business, legal, media marketing topics. We look for feedbacks from you as viewers out there to talk, to send in questions about maybe future topics
To
that
get
you'd like to
involved,
hear. Right?
Right.
And so we're happy to do that. Your feedback means a lot to us because that's how we really shape the show. We're here to help you as small business owners to get organized and to do the best you can with media marketing. Right, Bill?
Right, exactly right. And we can be found on a number of different media sites. So why don't we give them that right away, Rick?
Right. If you are listening to us on Blog Talk Radio today, you can find us obviously on Blog Talk Radio. Just type in Bottled Business Sense Show. If you like to see the simulcast, you can log into our website at bottledbusinesssenseshow.com. You can contact us on Gmail if you would like to be a host, want to be a sponsor, or just have questions you'd like to feed into the show. You can reach us at bottledbusinesssenseshow@gmail.com. We're also on social media at Facebook, LinkedIn, and Google Plus at Bottled Business Sense Show, and then you can tweet in questions or comments on Twitter at BB Sense Show.
Great, Rick. Thank you. And I always find that the simulcast on our website is the best way to go because then you can actually see us and hear us, and you'll be able to tell if we're keeping up with all the latest fashion trends.
Well, with that being said, Bill, I'm excited to hear about what you have to teach us today about Estate Planning 101.
Yes. Well, the question, what is estate planning? Believe it or not, I hear it more often than I care to think about. But that's how people learn. And actually, estate planning really encompasses three things, really. The planning of your personal assets and how those are going to be passed on when you die. The asset protection plan of your business assets. And, of course, financial planning when you go to see the financial advisor. So estate planning encompasses a full gamut of planning, including asset protection. Of course, we're going to touch upon that today because protecting your business is one of our fortes here, and we're going to show how the estate planning principles tie into that.
Oh, very good. Well, tell us how we start with forming a trust.
Well, and I'm glad you asked that, Rick, the way you did, because people always say, what do I need? Do I need a trust? Yes, you need a trust. But what I like to refer to it as is a trust package. People don't understand, some people don't. When you get a trust, you're not just getting a living trust, or at least you shouldn't. You should get a trust package, and that encompasses some 10 to 12 documents. That encompasses powers of attorney for assets, powers of attorney for healthcare directives. It encompasses a pour-over will. It encompasses a living trust. It encompasses a trust affidavit. So we're talking about a multitude of documentation that comprises your estate planning package.
So is that something that when you form these trusts for your clients, is this something that you do, or that the way you shape that and explain to us here, or is that standard practice?
Well, everybody, just as when you form a business entity, you sit down with your lawyer and you say, what are your goals? What are the goals I want to accomplish? Because there are many different types of trusts. First of all, we have revocable trusts and irrevocable trusts, which in and of themselves can be a separate program. But then you also have different types of trusts that incorporate specific goals of depending upon what person wants to accomplish. But let's say you want the basic living trust that is going to have as its goal to pass on your assets when you pass, when you die, without the need for probate. Okay? And that's really the key as to what are the benefits of having an estate plan.
Okay. So correct me if I'm wrong. Is that the same as doing a will, or is that different?
No, a trust is not the same as a will. What you do is you have a pour-over will as part of your trust package. Best way to explain it is this. You have a living trust, and by the way, the word trust was developed from Roman times. They decided they were going to put their trust in each other and pick out a trustee to run and pass their estates along, and that's where it originally came from. But what you would have to do is the assets that you pick out and put in your trust may be believed by you to be the totality of your estate. But let's say you forget something, or let's say you come into some asset later on and you neglect to provide it and put it in your trust. A will, the will that accompanies the trust package, is called a pour-over will, because what you're going to want to do is petition the probate court and said, look, Judge Mary Jones left this out of her estate, but look at how she put everything else in her estate. She really would have intended this new asset to be in her estate as well. So what we would like you to do is have it pour over into the trust just as if it was placed in there with all the other assets at the same time they were placed in there.
If that's the case, in your experience, how do you find the judgments typically going when something like that happens?
Well, when you say judgments, how the judgments go, you mean?
Do they?
How do the courts
that?
respond to something like
yes.
that? Very typically, courts are very inclined to just include that in the estate as long as you have the pour-over will that accompanies that living trust.
Okay, so that's the key.
So that's the key.
Yeah.
You also need, as I mentioned, a power of attorney for assets. One of the benefits of having a living trust is to be able to get into a plan for your incapacity. You could be incapacitated from some disease, either mental or physical. You're going to want to have somebody be able to take over and run your assets. The trust package, by way of the power of attorney for assets, provides that. Same with the power of attorney for health care. You may be incapacitated. Somebody will need to make your health care decisions. You need that power of attorney as well. And then, of course, you have your health care directive, which indicates how your remains are going to be disposed of at the time of your death according to your specific wishes. So there's a lot of things involved here. But I wanted to touch upon very briefly, before we go into the specific benefits of an estate plan, I wanted to touch upon revocable trusts.
Yeah, we have a question here from viewer Sam, and he asks, is it revocable?
Well, trusts can be revocable or irrevocable, and depending upon what you intend to do with your assets, including your business assets, that could play a big role. For example, any basic living trust that you get will be revocable if that's the way you want it to be. You can specify that the trust can be revoked at any time. That's stated within the trust document. If you have an irrevocable trust, you now have a trustee, someone who runs the trust, that is someone other than yourself. So let me set the stage here. In a revocable trust, the one that you can revoke, you can be the trustee and the originator of the trust, meaning that you've created the trust and you're running the trust, or you can be the creator of the trust, referred to as the settlor or grantor, and have a neutral third party be the trustee. Either way, you can have that done and it can still be revocable. If you have an irrevocable trust, however, You cannot be the trustee. You must have an independent third party be the trustee, and then that property, any assets that you have, personal or real, in that trust is now owned by that trust, not you any longer. And that's where the true asset protection comes in, which again is a whole nother show.
So if you can briefly just explain for the viewers, or give us an example of when you would do a revocable trust and an irrevocable one.
When you want to do a revocable trust, you want to do it because you want to have control of your assets. You want to be able to take them in and out of that trust as you so choose. The IRS is very specific in recognizing that those assets still belong to you when they are in a revocable trust. So a revocable trust provides no asset protection. It provides mainly an estate plan for allowing those assets to pass free of probate court and free of probate costs. With an irrevocable trust, now you're getting true asset protection because those assets no longer belong to you. You no longer have the right to control them. You no longer can take them in and out of the trust at your leisure. So that's the biggest distinction. Do you want to have control? Do you want to have somebody else have control? Somebody that you trust and who you hope and pray will do exactly what you want them to do with the assets that they now own. Yep. That would be irrevocable. But let's go back to the revocable trust briefly, because I want to say that in a revocable trust, you could still put your business assets, you could still put your units of an LLC that you own, or your shares of an S corporation or C corporation that you own. You can put those in the trust. You will have the asset protection that that business entity provides, but no more. The reason they're in the trust, a revocable trust, would be so that those units or shares can pass as you want them to your heirs. Okay? Now, if those same units or shares are in an irrevocable trust, now you have the asset protection of the business entity and the trust itself, because with an irrevocable trust, the trust would have to do something wrong in order for it to even be sued. Whereas if you have if you have your assets in an irrevocable trust, someone can still sue you and reach whatever's in the whatever it is in the revocable trust. So, not to confuse people, but let's recap this.
Oh, before you do that, I have a question, because you said something that was a little interesting. So,
sure.
When you said if the trust does something wrong, what did you mean by that?
Well, that's where we have a irrevocable situation. Okay, and that's what I was going to recap. So the viewers and listeners aren't confused. This is real important. If your assets are in a revocable trust, one that you can revoke at any time, they are not protected from any lawsuit. So if you're sued, they can be reached. Now, let's say you are sued, the assets in your trust are reached, but some of them are personal assets and some of them are business assets. Well, your business assets that are in your revocable trust are still going to have the protection of that business entity, right?
Makes sense. Okay.
Okay?
Yeah.
All I'm saying is that if anything can be reached when it's in a revocable trust, it will be reached under the right circumstances, because those are your personal assets. If part of your personal assets are also business assets, then you have to be able to reach those business assets in the way you normally would, by finding a way that to provide access to those business assets. In other words, a business would have to do something wrong. Okay. Now, if your personal assets and your business assets are in an irrevocable trust, they belong to somebody else, the trust. In order for those assets to be reached, the trust would have to do something wrong, not you, because the trust is a separate entity, totally.
Meaning what? Like, give me an example. How the trust could do something wrong.
Well, the trust would have to enter into some sort of a contract and breach the contract. The trustee of the trust would have to commit fraud or do any of the things that someone else would do who has a revocable trust. But most oftentimes that's not happening. If your assets are in an irrevocable trust and they belong to that trust, then you're acting over over here as yourself, and if you do something wrong, somebody might be able to sue you, but there's no way they're going to reach that trust unless they can also prove that that trustee and that trust is doing something wrong, which happens to be the same thing that you're doing wrong, which is very unlikely. Okay? So, revocable and irrevocable gets into some territory that really needs to be explored thoroughly. A lot of times people who have large estates, people that have assets that they want to make sure are totally secured, people that have third-party trustees. Many people pay for third-party trustees in order to have a neutral third party who's going to do what essentially they want that trust to do. Those are the people that are going to run and have an irrevocable trust. But remember, when you have an irrevocable trust, you have no control of those assets. It's controlled by that third-party trustee because those assets now belong to the trust, which has a separate independent tax ID number. You have a revocable trust. The assets are in there for purposes of passing easily, bypassing probate court, but those assets still belong to you.
Okay, that clarifies it for me. So let me ask you this before we head into our first commercial break. If you go the irrevocable route, right, and you set up your trust, can you go back and change it at any time, or is it locked?
Not if it's irrevocable, no.
Can anyone change it?
There are very specific circumstances under which an attempt can be made, but that is very, very intricate, and it's certainly not fodder for this show today. That's something we'd have to discuss on a separate show, and we will. Okay. But what you should know is that once it's irrevocable, if you plan on getting an irrevocable trust, you should plan on it never being changed. That's the whole idea of it.
Right. All right. Well, this is extremely valuable information, and we'll talk a little bit more about the benefits in the second half of the show. But at this time, I think it's a good time to share with our viewers one of our sponsors.
Yes, one of our great sponsors would be StriderWatches.com. That's STRIDER. Watches.com. Strider Watches is owned by a friend of mine named Jim Skelton, and Jim is a host on a show aired on DirecTV Channel 227 every Saturday and Sunday evening Pacific time from 3 p.m. to 6 p.m. and it's called World of Watches, worldofwatches.com. You can also go there to watch the show. In any event, Jim has developed over the course of several years his own watch company and his own style of watches. And I believe his first watch is the Hyperdive, which can be viewed on his website. Jim has a tremendous amount of knowledge about watches, very, very knowledgeable guy, and more specifically has worked with all of the major watch companies in the industry today, and has helped them design specific watches. So I would urge everybody who loves timepieces like I do. These are timepieces that they're wonderful, and they're more than just telling time to me. It's men's jewelry, and that's why I like them so much. That's why I appreciate what Jim does. Anybody can look at a cell phone and get the time, but if you want a piece of art on your wrist, if you want the symphony of time on your wrist, then you're going to want to invest in some nice timepieces. And Jim Skelton is the man to see at StriderWatches.com.
Excellent. And folks, if you want to take a look, go to the website. He's got an incredible piece that he's offering in the Hyperdive watch. So catch him on his website, or like Bill said, on World of Watches on Saturday and Sunday.
Yep.
All right. We're going to go into our second half of our show. Bill's going to talk a little bit more about the benefits of estate planning.
Right. And remember now, we've talked a little bit in the first segment about estate planning for personal assets, and we've melded it into the protection of business assets and how you can go that route by going from a revocable trust to an irrevocable trust. Now I want to talk about the benefits of trusts in general. And of course, the premier one is avoiding probate. When you go to probate, several things can happen. Attorneys make money, courts make money, and a probate can last anywhere from a year to 3 years, maybe longer if there is some sort of a dispute involved. The whole point of a trust is to have it and let the assets pass freely and quickly. A trust provides privacy. When you have a probate court, situation, when you have no will and no trust, or if you have a will and no trust, under those circumstances you go to probate court. It becomes then a matter of public record and people know everything there is to know about your estate. With a living trust, you don't file any documentation with the court system. So you have complete privacy and your estate is personal. Another benefit of having a living trust package. We touched upon it, I think, a little earlier, Rick, about incapacity.
Yep.
And what I mean by that is that you have the ability through powers of attorney and through provisions in the trust to be able to have someone step in and take care of your assets, run your business, run your estate, do whatever's necessary to keep things moving. And we also, of course, have the power of attorney for health care, which allows somebody to make decisions for you if you're incapacitated from a health standpoint. So those are all important benefits. One of the things I like to bring up, I think that sometimes people lose sight of, Rick, is you may have real estate. You may be a real estate investor, for example, and you may have real property that are in several other states. If you don't have a trust, when you pass, your family members have to travel to that state and probate that property in each of the states where that property is located. With a living trust, the trust comes in, swoops in, grabs all those properties and puts them in the trust, and they all pass by way of the trust in the state where the trust was drawn.
Yeah, that sounds like a potential nightmare if you're not organized correctly.
Well, again, we've talked about this on the previous show, where people will, it's so expensive to get this thing done. Why do I want to do it now? Well, I have to be candid with the audience. There's really one reason why people don't do it now. It's not because it's too expensive. Because I've seen people say, I'm going to go out and buy 3 big screen TVs and put one in each room before they decide on an estate plan. And, isn't that typical that many times people often buy what they want, right, rather than what they need?
Yeah, exactly. Right.
So what I've found is the reason most people don't have an estate plan who decide, I should say, the people that do not have an estate plan, the reason most often that they do not is because they become selfish. They take the attitude, well, why do I care what's going to happen to my estate once I pass?
Yeah, it's pretty.
Let my family deal with it.
Pretty selfish of them.
Let my heirs deal with it. Right. So, but really, what are we protecting? What are we using an estate plan? Who are we protecting it from? Well, we talked in our prior shows about business asset protection from malicious litigation, right? Mm-hmm. What about protecting your estate from probate court and the state? Because the probate courts are going to make money off your estate that you worked so hard for. Think of it that way. That's another aspect of protection. You're protecting your personal assets. In addition to your business assets, you're protecting your personal assets from invasion. Because if you don't protect them, then somebody else is going to get the money that you worked so hard to get.
Right. Let me ask you something here. There's another question that came in from viewer John, and if someone were to go irrevocable trust, right, and that's all set up, and you pass, and in some fluke accident, the person that's controlling the trust or managing the trust also passes, what happens then?
Do you mean if the trustee or the person who's controlling the trust, what happens if that person is gone at the same time you're gone?
Yes.
Well, then what you normally do when you have this trust package set up is you provide for successor trustees. Let's take an example.
Okay.
If you have a revocable trust and you are the creator of the trust, you are called the settlor or the grantor. Either phrase will do. You can also be the trustee, meaning, for lack of a better way to say it, the person who has the fiduciary duty and responsibility of running that trust. What are some of the duties? Making money for the trust is one of the fiduciary duties that a trustee has. Making sure the assets are secure, they're not invaded, nothing happens to them. that trustee, if it is you, in addition to being the settlor, you must have a successor trustee that will step in and take over if something happens to you. Normally, in a family situation, if you have co-trustees and co-settlors, people who create a trust in a marriage, then there's no issue. It just, the wife will then become the sole trustee of the estate. If you are not the trustee and your wife is not the trustee, then you're going to have a third-party trustee. If that person passes before you, you want to have successor trustees named in the document who step in and take his place, his or her place.
Okay.
Now, if you are the wife and the husband and you're both the creators of the trust and you're the co-trustees, well, then under most circumstances, once you both pass, then the trust will be distributed unless it's going to be a specialized trust that continues on, and in that case, you're going to provide for other trustees in the trust document. So you never have a situation where you run out of trustees, is the simplest way to put it, as long as the trust is set up correctly.
Okay.
So I hope that helps you, John.
Yeah, that makes sense. We have one more question here from viewer Patricia. She just got this email here. She asks, so once the trust is set up and all the documents have been completed, is your property in the trust?
Very good question. I think what she's saying is, if I'm reading it correctly, is it automatically put in the trust once the trust documents are prepared? No. You must fund the trust. And it's so more typical than I'd like to think, where people, attorneys don't normally go around and after the trust package is prepared, go into banks and go into the county offices and do all of the transferring of title. No, we don't do that. We might prepare a deed for a particular piece of property or several pieces of property, but then it's up to the creators of the trust to go in and take care of business. So if you don't take your personal property and your real property and change the name of that property into the name of the trust, then that trust is not funded. And even though you've paid for a trust package and you pass, it's going to be just like you never had a trust and you're going to end up in probate court. So if Rick and Bill own a piece of property, and they have a trust, then they want to make sure that that property is then going to be put into the name of the trust. You and your wife own this house together. You're going to want to make sure that instead of Rick Moscoso and Tammy Moscoso owning the house as joint tenants or husband and wife, it's now going to be transferred into the ownership of the Moscoso Family Trust.
Okay.
Or whatever name you choose for the trust.
Right.
The same with your bank accounts and your investment accounts. Most often, and there are exceptions, most often life insurance policies, IRAs, 401ks, they are their own mini trusts. They have their own built-in beneficiaries. So you typically do not put them into the trust. You don't fund them into the trust.
Okay. All right. We're coming up towards the end of the show here. Bill, do you have any more you'd like to share? I mean, this is a wealth of information for our viewers out there. And there's a lot of topics that we could actually break away from this and have a show on its own.
Yes. Well, I want to touch upon the business aspect of the show, the business protection aspect of the show very quickly, and that is make sure that when you have businesses that you have, LLCs or S corporations, some agreements incorporated into those businesses will prevent the businesses from taking on other people into the business. So in other words, if you have units of an LLC or shares of an LLC and you put them in your trust and want to pass them on to somebody else when you die, the business owners that you're in business with may not want to do business with that new beneficiary. So you need to check and make sure that these agreements are either set up to allow that to happen, or you want to make sure that you have some discussion somewhere down the line to make sure that that your assets that are passed on to your heirs are going to be functional. It may just be that that the units or the shares of the LLC or the S corporation or C corporation are passed on to the heirs, but then they're forced by way of the agreement to sell it back to the remaining individuals in the company. So just kind of a heads up on that. That's something where you should sit down with your lawyer and make sure that that's all squared away at the time you prepare your estate plan.
Okay. Yeah, folks, it's very important that you do that. If you are looking to do any type of a trust, that you really sit down and have your goals in mind when you're discussing your assets, your business, and forming a trust around that. So your attorney definitely is your friend when it comes to
that's for sure.
forming a trust.
And on that note, you can get a hold of me at WFB Legal Consulting Incorporated at wfblegalconsulting.com. Email is bill@wfblegalconsulting.com, and phone numbers are 949 area codes 413-6535 and 698-6222.
All right.
So I'm happy to help you out in any way I can.
Absolutely. If you have any questions for Bill, send your messages into his email. Give him a call. He'll be happy to see how he can help you. Or just email us into the show at bottledbusinessshow@gmail.com.
And real quick, Rick, what's on tap for next week's show?
Well, next week is pretty interesting. It, again, has to do with media marketing. And what I'm going to talk about is really the 3 W's of personal branding. All right. What is personal branding? Who is it for? And why do we need it? All right. So
Good.
It's something that we tend to ignore or really don't focus on in our businesses, especially when you're first starting, or maybe you're established and you're trying to really create a brand for yourself. These are really 3 important things that you need to be aware of.
Well, this is a subject near and dear to my heart. I've always been interested in this, and I'm really looking forward to hearing more about it next week.
All right.
So, folks, please tune in and join Rick and I next week for that. And in the meantime, please visit us at our sites and ask any questions you'd like. See if you want to be a sponsor. See if you want to come on the show and talk a little bit about your business. And we're happy to have you.
All right, Bill. Well, thank you very much for a great show. A lot of good information on Estate Planning 101. We will see our viewers again next week, 10 o'clock on Tuesday.
Okay. Take care, everybody. Looking forward to seeing you next week.